Hello and welcome to the Arbitration Conversation. So in this webisode, we are going to be talking to Professor Andrea Bjorklund. Andrea Bjorklund is has been a professor of law, first in California, then in Montreal at McGill University. She's a full professor and she is the chair in international arbitration and international commercial law, but she's also the associate dean for graduate studies at McGill University, which is the top law school in Canada. Also, she is the advisor to the American ALI's, the American Law Institute's project on restating the U.S. law of international commercial arbitration, and she's a member of the advisory board of the Investment Treaty Forum of the British Institute for International and Comparative Law. She also, prior to being a professor, she was the attorney advisor on NAFTA arbitration team in the Office of the Legal Advisor of the U.S. Department of State. I could go on. She has amazing credentials. She's absolutely brilliant, and I feel so fortunate that she would join us here because I also got to meet her and have dinner in Paris. So too bad we're not in Paris, but boy, am I super thankful that you took time with us.
Gosh, Amy, well, thank you. That was a very generous introduction. And I too wish we were in Paris or in Montreal or in Colombia, but at least not on Zoom. But it's very nice to reconnect with you in any event, even if it's virtual and not actual.
Yes, for those that are watching, we actually taught together on a Paris program for law schools. I guess it was through the University of San Diego, but we got to be in Paris teaching different aspects of international law. So boy, is it super fun to reconnect. But now we're talking about investment treaty arbitration. And I know that you were part of Working Group 3 and had participated with Working Group 3 of the Untitled dealing with investor-state arbitration. Could you tell me a little bit about that and sort of how you got to be involved in the working group?
Well, sure. So I've been working now in investment arbitration for about 20 years, a little more than 20 years. And when Untitled decided to take up the potential reform of investor-state dispute settlement, of course, I wanted to be involved. So I was lucky enough to be one of the representatives named by the International Law Association, which is an accredited organization by Untitled. So I'm an NGO, representative, but I'm one of the ILA people going. I go with Catherine Kasajan usually, and sometimes with August Reinisch. So it's a nice opportunity to be there to see a little bit about what is going on. I've been to Vienna a couple of times and New York a couple of times. They're going to try to have a meeting in Vienna in early October, but it's going to be a hybrid meeting. So those who are in Vienna can be there, and those who are not in Vienna, I think, will be able to take part, via Zoom or some other appropriate platform. But I am also lucky to be able to be with the academic forum. Untitled set up an academic forum to kind of parallel the Working Group 3, and I'm one of the deputy vice chairs of the academic forum. So that's been a really rewarding position as well.
Oh, that's so important, I would imagine, especially with working on the restatement and all the rest that you've been doing in the area. So I'm wondering, what kind of reforms do you think, what is the potential for Working Group 3, and what sort of reforms do you see as on the horizon?
Well, so multilateral groups are always a little bit complex and usually not terribly speedy in their resolution. But of course, the benefit is that you have the opportunity to involve in a wide array of stakeholders to seek a resolution that really does please, more rather than fewer people. I think the range of possibilities is still significant, and some of these are not altogether mutually exclusive. So the biggest, I think, jewel that is being sought by the European Commission in particular is the establishment of a multilateral investment court. And that would be a court that would, that every investment treaty could feed into. So the idea is that this would replicate the Mauritius Transparency Convention, where states could sign on to this treaty that would then say, okay, we're keeping our existing bilateral investment treaty except for the dispute settlement parts. And instead of having independent arbitration or ICSID arbitration, we're going to actually go to the MIC, to the Multilateral Investment Court instead. So then you could have, you would have multiple treaties, and we have more than 2,800 treaties in force. They could all conceivably feed into the same mechanism, which would avoid the necessity for amending each and every treaty, right? You would have a mechanism to do a global treaty amendment. A slightly less ambitious part would be to establish an appellate body. So instead of establishing a two-tier tribunal, you would have an appellate body. You would have arbitration at the first instance as provided for by the treaties, and then you could still sign in for this appellate body. And there's even a possibility of establishing a two-tier tribunal with so-called open architecture, so that you could either sign on to the two tiers or sign on only to the appellate body. Those are all potential things.
Would these international courts and these bodies that you're talking about, especially with the appellate procedure, would that all still be, though, considered within international arbitration, or are we now talking about a public body of some sort?
Well, that is an excellent question, Amy. And I don't know, I don't think I can give you a firm answer to that, because it hasn't been designed yet. It's not clear that this is even where things will go. Other possibilities, which I think we'll get to, are lesser reforms, or more reachable reforms, such as establishing a code of conduct for arbitrators, or something that could also happen even if you eventually had a MIC. But it's a little bit difficult because, of course, as you know, the best enforcement mechanisms now are the New York Convention on the Recognition and Enforcement of Arbitral Awards, or the ICSID Convention for investment treaty awards, when both disputing parties are party to, or have a home state that is party to, the ICSID Convention. So those are both arbitration mechanisms. So it's a little bit unclear what the enforcement mechanism would be if this is not arbitration. And when there's kind of an interim step in its investment agreement, the European Union has included what it calls an investment court system. So that is maybe a little bit of an intermediate step, but it calls for something a little bit like the appellate body of the WTO, where arbitrators, decision adjudicators in that system would be part-time, kind of on call, and if the work was such, they could be changed to permanent, but the awards would be considered arbitral awards and enforceable under an arbitration regime. I think for a MIC, they would probably think of establishing, it would be a permanent tribunal with permanent members and with maybe its own enforcement mechanism. But again, I think that's still in the future.
Well, some of their mandate, had to do with procedural reform, right? And
yes.
So when we really think about procedural reform, my question is to you, where do you really think they will end up? What do you think is doable, especially in the near term?
So I think in the near term, you could, I mentioned the code of conduct for arbitrators. That is, there's a draft code of conduct that's a cooperative venture with ICSID and Untitral and a few other entities. So I think that is a kind of low-hanging fruit. That is something that could come into play. There's still some dispute about things like issue conflicts and double hatting. Because this would be a code of conduct for, at least also for arbitrators. So can you be both counsel and arbitrator? Do you have to give up being one in order to do the other? I think that's still a little bit, there isn't necessarily agreement on that. You have some issues, I think some issues, transparency, which is already possible with the Mauritius Transparency Convention, but I think that is something that could be resolved relatively easily. There is, I'd say agreement that people want counterclaims, the ability for states to submit counterclaims against investors, but that's a little bit more complicated than it seems. I don't think of that as really only a procedural issue. And if you're making a counterclaim against an investor, you have the question of applicable law. So ordinarily, so this treaty as a procedural treaty wouldn't form a basis, I think, for a counterclaim. And since investors are generally private entities who generally do not have duties under international law, I recognize that that is something that is potentially changing, but I think that's still generally true. The most likely counterclaim would be based on domestic law. So you might have to query whether an investment treaty could be changed by this procedural device to include a provision to permit a counterclaim based on an applicable law that might or might not even be mentioned in the treaty. And then you have the further complication that the European Union, as you know, in the European Court of Justice, has reservations about international tribunals applying European law. So the European treaties say that the tribunals convened under them, this investment court system, the tribunals don't have the authority to apply EU law. So a counterclaim couldn't be based on EU law if the EU were involved. So then I think it's more complicated than it seems, even if in principle, the idea of counterclaims seems to have gotten relatively broad acceptance.
Well, and I've heard a lot of buzz about this idea about counterclaims, right? And that's been sort of a controversial issue. But I would agree with you that it's more substantive than procedural in light of all of the sort of complications, as you note.
Yeah.
Sort of thinking about complications. Yeah. And as we think about complications, I guess I'd also love to hear, I mean, yes, certain procedural forms might be possible. As you said, a code of conduct might be possible. I know there's ICA and others have had diversity pledges, and there's been a lot of different movement in these areas. But what do you think would be the ideal, like, next steps? I mean, if there were to be something that's doable, would it be the appellate provisions? Would it be, if we were to kind of boil it down to what could happen in October, for example?
Well, I don't think a lot is going to happen in October. I mean, I think this is a long-term project. I suppose, as maybe an incrementalist, I think that it would be quite interesting to have one of the investment court systems under one of the European Union treaties, whether that be CETA or the EU-Vietnam or EU-Singapore agreement or EU-Mexico. If one of those were established, I think it would be quite an interesting laboratory. It's not exactly the same. The MIC poses a few more complications. I'll talk about selection and appointment of arbitrators in a minute. But I still think that would be maybe a nice, experiment where you had maybe a smaller stakes attempt to establish this, that you could work out some of the hurdles and challenges that would undoubtedly be met. But you mentioned diversity pledges. It's, one of the interesting things about establishing a permanent court is that it really gives states the opportunity to live up to diversity pledges and to try to have a diverse, representative set of decision makers. On the other hand, you limit the numbers, and that automatically, in a sense, places greater stakes on each individual appointment. And to the extent you are not coordinating those appointments, you could wind up with all men. You could wind up with all representatives from Europe. You could not with anybody having bad intentions or motives, but if they're not coordinating, and I mean, you've probably done this when you've either been at conferences on panels or organized panels, you carefully have your gender balance, and then somebody drops out at the last minute. Oh, yeah. And you have to do something. And so if you're not really careful, your careful balance changes. And I mean, it could change in favor of women or in favor of men. It could go either way. But if you don't pay attention, I feel like if you just take your eye off the ball for a second, you can end up with results that you never really intended. And if you do something like is often done with international tribunals where let's say you have 5 people named by Canada, 5 by the European Union, and 5 on whom they agree together. If you've got 3 and 2, let's say 5-5, can't have an even number. Let's say the European Union says 3 men, 2 women, Canada 3 men, 2 women, and for the presiding group you say 3 men, 2 women. Then suddenly you are at a 9 and 6, which isn't too bad, but that's not, I'm going to say not great, and maybe nobody intended that, but that's something to consider. And gender is an easy one. I could say, well, more or less easy, but you've got national origin, you've got maybe you've got legal training, you've got race, you've got religion, you've got class, socioeconomic class, you've got global north, global south issues. Like that's a lot of things to consider to try to put in a small number of people.
Right. That brings me to, kind of other obstacles, right? Because it seems as though there are a lot of obstacles that Working Group 3 does face.
Mm. Yeah, I think those are, I think so, a lot of these are work outable. I just think that it takes, quite a lot of time to work them out. I think really the enormity of the task is hidden a little bit by the notion that you're just doing some procedural reform, because what you're really doing, in my view, is thinking of creating a system of dispute settlement that doesn't exist. Reform is really a slight misnomer because there's not really an existing system. That's one of the critiques, is that the system isn't working, but I would say there is no system. It was never designed to have a system. You were designed to have, tribunals convened on either on an ad hoc or institutional basis, but on a one-off basis to hear the disputes. They weren't meant to be systematized. So you can criticize that and say, well, there should be a system. And I think that's kind of where many people are now with respect to investor-state dispute settlement. But that really means you're creating a system. You're not taking a system and kind of fixing it a little. You're creating a system from scratch.
Yeah. I was just gonna, I agree with another notion that you put forth, is kind of this idea that sometimes when you're tinkering with procedure, you really are focusing on substantive reform. Procedure can quickly turn into substance.
Into substance. So you have to, when you're in the meetings, a lot of delegates, there's a big educational process going on. A lot of delegates are very knowledgeable. They, their country has been a respondent in investor state cases. They know a lot. Some are less experienced. So they're really, there's a big educational component. And you do see, one of the concerns is consistency and predictability of results. And you'll see concerns about the fair and equitable treatment standard and what it means. And, procedural reform is not about changing the fair and equitable treatment standard. It's about maybe setting up an appellate body who could try to bring some greater clarity to that. But with 2,800 treaties or more feeding in, with some of which have really different standards, some of which are really relatively similar, that won't necessarily come easily. And you also are a U.S. attorney, that in the United States, we have a due process provision, the constitutional protection provision that has, now been around for well over 200 years. And I don't know that anyone would say that we have a predictable jurisprudence around the due process standard in 200 years, or even 100 years if you just count the 14th Amendment. And, I don't know. A lot of these cases are very fact specific. So it's a little bit, I think it's asking a lot for an appellate body to bring real consistency in this area, or the consistency that people might be wanting.
Right. Well, gosh, I certainly look forward to watching what happens and what eventually unfolds and
Yeah.
where we end up with this. And thank you for your service and working as part of this. That's really important stuff. So certainly thank you for taking time with us, and thank you for yeah, being here in my Zoom room. I wish again that we were in Paris, but we're not.
We will meet again, and we will meet in Paris, and have a little bit, have a glass of wine, and talk about the days when we both lived on, in fourth floor walk-ups in, up tiny staircases with no elevators.
Oh, and loved every minute of it.
And absolutely.
All right, thank you so much.
Thank you, Amy.